this one.
Now you're going to college?
I forgot all about it.
I thought I wanted to be an environmental lawyer. Oh, no. And that's where you go.
Well, actually,
And I surveyed the job market and realized there weren't enough jobs. So I pivoted to other kinds of law I like and came back.
Or is it blinding you?
But now you don't do that.
Nope, I moved to the side. Maybe once a year. Rarely.
Now I see Elburn's with you guys.
Yeah, he joined us. It's fun to work with him. I've known Tom my whole life, so.
Yeah, he's a pretty smart dude. He's had a lot of,
Okay.
experience.
You have one more.
I knew
Okay.
his dad.
Sure. So they have a lot of,
You have one?
I don't, yeah, I have an adapter I
Sitting
could use,
here.
but I don't think we're right.
having a senior moment on the one partner, the accountant, no partner.
Bless you.
He was the
For the
accountant.
record. Right.
She was standing there. Roberta. Jesus, anyway, that was her dad. And I'm good friends.
We're fine without that.
But, geez, he used to
Look
have
at,
a name.
it's just the
But
hell.
anyway.
It'll come to you during the
Back
day.
here.
Yeah. Also, hey, what were we talking about? He said, what were we talking about? What kind of farce do you know?
Honestly,
The binoculars to see.
Are we
wait,
recording?
you sit up closer?
Well, then that would...
All right. I'd like to call the Board of Zoning Appeals regular meeting to order, Monday, September 17th at 5 PM. It is 5:03. Roll call, please.
Mr. Lamana,
Present.
Mr. Schlechter,
Here?
Mr. Miller,
Here.
Mr. Hayes,
Here.
Mr. Levine.
Here. Have you all had an opportunity to review the minutes from last meeting?
I have.
Have any comments?
None.
Okay.
Move to approve?
Second?
Mr. Levine,
Yes.
Mr. Hayes,
Yes.
Mr. Lamana,
Yes.
Mr. Schlechter,
Yes.
Mr. Miller.
Yes.
So from our prior meeting under old business, we were discussing the appeal of zoning administrator's determination of a violation of section 201-A, which is farm animals on lots less than an acre of the Sylvania Township zoning resolution for the property located at 9328 St. Angela's Way. So at this point in time, we're going to make a quick adjournment to further discuss this matter, and then we'll be back out and continue with the hearing.
Just, Mr. Chairman, I abstained from this vote last time, so
Okay,
I will
so
step
we
out to
will
the audience.
accuse Mr. Lamana, and you can come back up when we get to the next new business. I'll call the meeting, maybe not, I'm going to wait for the recording device. Call the meeting back to order at 5:16. So I will entertain a motion on this matter.
I'll make a motion to adopt the findings of facts and conclusions of law related to this matter.
Thank you. A second?
Second.
Okay, could you read those findings, please?
Certainly. In late April 2018, the Sylvania Township Zoning Department received an anonymous complaint of a pig on an R1 medium-density residential zone property located at 9328 St. Angela's Way, parcel number 7973472. The Township Zoning Compliance Officer made a couple of attempts at verifying that complaint, but was unable to confirm the presence of a pig at the subject address. In early June 2018, the original complainant provided photos of the pig in the rear yard of the property in question. In accordance with Section 3203 of the zoning resolution, a notice of violation was sent to the property owners Todd P. and Melissa J. Crandall on June 11th, 2018. The notice was for violation of Section 201A of the Sylvania Township zoning resolution, maintaining a farm animal livestock on a lot 1 acre or less. On July 9, 2018, the Crandalls filed an appeal of the zoning violation notice in accordance with Section 2404A of the zoning resolution. The basis of the appeal was that the Crandalls wished to keep their comfort animal and domesticated pig Milo in their home. On August 6, 2018, as required by Section 2401 of the zoning resolution, this board held a hearing on the Crandalls' appeal. The hearing was recessed and continued to September 17, 2018, pursuant to Section 2401B of Sylvania Township zoning resolution. A zoning violation hearing is an adjudicatory hearing. An adjudicatory hearing determines the rights of specific persons based upon direct evidence presented. This board's decision must be based on the preponderance of substantial, reliable, and probative evidence present in the record. Reliable evidence has been defined as dependable. That is, it can be confidently trusted. In order to be reliable, there must be a reasonable probability that the evidence is true. Probative evidence is evidence that tends to prove the issue in question. It must be relevant in determining the issue. Substantial evidence is evidence with some weight. It must have importance and value. Testimony must be by affidavit, deposition, or oral examination. In order to have any evidentiary value, the witness's testimony must be under oath. Unsworn testimony cannot provide the preponderance of substantial, reliable, and probative evidence necessary to support a decision by this board. Furthermore, witnesses must testify about relevant facts and not their subjective and unsubstantiated opinions. Unsubstantiated opinions do not rise to the level of reliable, probative, and substantial evidence. The property in question is located at 9328 St. Angela's Way, Sylvania, Ohio 43560. The property is owned by Todd P. and Melissa J. Crandall, parcel number 79-73472. The property is in the 12 Lake subdivision, Plat 6, Lot 102. The property is located on the north side of St. Angela's Way, approximately 300 feet east of Breeze Bay Drive. The subject property is zoned R1 medium density. The land use plan recommendation is low medium density residential. The property is .293 acres, 12,750 square feet. The lot frontage is 79 feet on St. Angela's Way. The lot depth is 150 feet. The residence was built in 2003 and is 1,778 square feet. The Crandalls purchased on March 2, 2018. They rented the property prior to purchasing it. Adjacent areas are all zoned R-1 residential single-family dwellings. The Crandalls obtained the pig as a pet for their daughter and not as an emotional support animal. A medical provider did not suggest that the Crandalls obtain an emotional support animal. They had the pig when they moved into the property. Throughout the hearing, the pig was referred to as a family pet. The pig has a room in the basement and lives inside the house most of the time and is a quiet animal. A witness testified that the animal is an 18-month-old mini pot-belly pig. Todd Crandall was a substance abuser for 13 years. He has been drug-free for 25 years. He testified that the animal helps him be a better person and better father. The pig is a lifeline for the family. The property owner submitted a letter dated after the zoning violation was issued from Ross Shaban, M.E.D. Mr. Shaban is with Health Connections, a counseling service. He has been treating Mr. Crandall since April 2013 for anxiety issues. The letter stated that, in Mr. Shaban's clinical judgment, if Milo is removed from the home, Todd will more likely decompensate and many of his dysfunctional behaviors will return and potentially get more severe. The letter further stated that it was Mr. Shaban's professional recommendation that Milo be designated as an emotional support animal. The letter also stated that Mr. Crandall had a generalized anxiety disorder, DSM-F41.1. At the hearing, The property owners asserted the following defenses to the zoning violation and/or arguments in support of the request for a variance allowing them to keep the animal on the property. 1. The pig is not livestock or a farm animal. 2. There is no rational basis for setting 1 acre as the limit for prohibiting farm animals or livestock. And 3. The property owners are entitled to a reasonable accommodation that would allow them to keep the pig on the property in question since Mr. Crandall is disabled. This board may, in conformity with the provisions of the zoning resolution, reverse or affirm, wholly or partly modify the order, requirement, decision, or determination appealed from, and shall make such order, requirement, decision, or determination as in its opinion ought to be made in the premises, and to that end shall have all powers of the zoning administrator from which the appeal is taken. Sylvania Township Zoning Resolution 2404D. Raising, breeding, dairying, or maintaining farm animals, livestock such as horses, pigs, cows, sheep, goat, chickens, or other similar livestock or fowl are prohibited on lots of 1 acre or less in any platted subdivision. Sylvania Township Zoning Resolution STZR 201A. Farm animal is defined as any animal that customarily is raised for profit on farms and has the potential of causing a nuisance if not properly maintained. Sylvania Township Zoning Resolution definitions. Livestock is defined as generally accepted outdoor farm animals such as cows, goats, horses, pigs, barnyard fowl, etc., not to include cats, dogs, and other house pets. The property owner argues that the pig is neither livestock or a farm animal since it is not being raised as a farm animal and it is not livestock since it is a pet. The zoning resolution does not state that the animal will actually be used as farm or livestock, but only that it be within the class of animals defined as farm animals or livestock. Pigs are specifically included within the definition of livestock and specifically prohibited by the zoning resolution from lots less than 1 acre. The property owners also argue that the 1 acre lot size limitation on prohibiting farm animals livestock has no rational basis. Zoning regulations are presumed constitutional. To be unconstitutional, it must be beyond fair debate that the zoning resolution is arbitrary and unreasonable, having no substantial relation to the public health, safety, morals, or general welfare. However, a Township Board of Zoning Appeals has no authority to consider constitutional issues. Therefore, since this board has no jurisdiction to consider constitutional issues, it must presume that the 1 acre limitation is constitutional. Todd Crandall asserts that he is disabled and entitled to a reasonable accommodation permitting him to keep the pig as an emotional support animal, even if prohibited by the Township Zoning Resolution. Under the Fair Housing Amendment Act, prohibited discrimination encompasses a refusal to make a reasonable accommodation in rules, policies, or practices when such accommodation may be necessary to afford a person equal opportunity to use and enjoy a dwelling. To qualify for a reasonable accommodation, Mr. Crandall must suffer from a handicap or disability as defined in the FHAA, a physical impairment which substantially limits one or more major life activities and a record of having an impairment. The only evidence of Mr. Crandall's disability is the June 23, 2018 letter from Ross Chabon. There is no testimony under oath regarding his alleged disability. The reasonable accommodation provision of the FHAA prohibits enforcement of zoning regulations in a manner that denies people with disabilities access to housing on par with those who are not disabled. However, the FHAA does not abandon the deference that the law has traditionally shown zoning codes. The FHAA does not provide a blanket waiver of all facially neutral zoning regulations. To be reasonable, an accommodation cannot impose a fundamental alteration in the nature of the zoning program. An accommodation is not reasonable if it requires a fundamental alteration of the applicable zoning scheme. Sylvania Township has adopted a comprehensive zoning plan. The Sylvania Township Zoning Resolution includes one agricultural district, A-3 for 1 acre minimum lot area, 7 residential zoning districts ranging from A4 rural residential to R5 multifamily residential with varying minimum lot areas, 3 commercial zoning districts, neighborhood commercial, general commercial, and professional business office, 3 industrial zoning districts, light industrial, restricted industrial, and heavy industrial, a manufactured home park district, a special district for public or semi-public land uses, a planned unit developments overlay district, and a Central Avenue overlay district. Sylvania Township Zoning Resolution, Section 302. Most of the township is zoned residential, primarily single-family residential, consistent with the predominant land use. The permitted and conditional uses in residential districts are based on the density of residential development and the availability of public services. The more dense the residential development, the more restricted are the permitted and conditional uses. The intent of the Section 201 of the Township's zoning resolution is to protect residential properties in medium and high-density areas from potential nuisance or harmful effects from the maintenance of farm animals and/or livestock. Based upon the preponderance of substantial, reliable, and probative evidence, this board finds the following. A, the pig known as Milo is a farm animal and/or livestock and is specifically prohibited from being kept on the Crandall's property pursuant to Section 201D of the Sylvania Township Zoning Resolution. B, Todd Crandall does not suffer from a disability as that term is defined by the FHAA. C, the accommodation sought by the Crandalls is not reasonable, since it would fundamentally alter the township's zoning plan. Therefore, this board upholds the zoning violation and orders that the pig be removed from the property within 30 days from today.
Thank you, Jason. Take a call for the vote, please.
Mr. Hayes.
Yes.
Mr. Levine.
Yes.
Mr. Miller.
Yes.
Mr. Schlachter.
Yes. So generally what that means is that you will receive notice in 30 days of what the ruling was. The ruling was that the pig must depart. We do have here at the desk a copy of the statement that Jason read for us. And you will, within probably the next 2 weeks, you'll get a notice from the township directly reaffirming this. So that concludes our old business. Those who are here on behalf of that hearing can stay if they'd like as we go into new business, or give you a moment to depart. While we're doing that, we'll welcome back Greg. Okay, before we move into new business, I'd like those that plan on testifying in any one of these three matters to stand and raise your right hand for me. Do you swear the testimony you're about to give is the truth to the best of your knowledge?
I do.
Thank you. Appreciate that. So our first matter is a conditional use for a kennel within an M1 district for the property located at 3315 North Centennial Road, parcel number 78-28706, Sylvania Township Zoning Regulations, Section 1602. Apparently, if we could have your report.
My report first? Okay.
Sure. I apologize that we have technical difficulties here. Usually we have some nice pictures and such on our board here, but Not today, so we'll work around that. Go ahead, please.
Yes, the property is located, it's a, as you said, it's a conditional use permit for dog training and boarding facilities, owned by the Finley Business Partners, and the applicant and agent is Kristen West Hamilton from Sit Means Sit Dog Training. It's located on the north of Central Avenue and south of Brent Road on the western side. It's zoned light industrial. It is a commercial warehouse, light industrial business park. And the adjacent zoning and land use has undeveloped to the north, M1 light industrial mines and quarries. And then to the south, there is a restaurant, I think it's the Barn, if you can, that helps you orient where we are, which is C2 General Commercial, and then the east is undeveloped, and the west is undeveloped, both of those being M1 light industrial. The only parcel history that I had on this was that the site plan review for commercial warehouses with rental units was administratively approved in November of 2012. The applicable zoning regulations include Article 16, M1 Light Industrial, Section 1602 Conditional Uses, Article 22 Supplemental Regulations, with Section 2204 being an animal care facility, Article 25 Conditional Use. Definitions include a kennel, which is an establishment licensed to operate a facility for the housing of domestic or exotic animals, pets, and where grooming, breeding, boarding, training, or selling of animals is conducted as a business, but exclusive of those animals used for agricultural purposes. Staff analysis. The applicant has requested a conditional use permit for operation of a dog training facility at 3315 Centennial Road. The property currently has 4 of 7 approved multi-tenant light industrial buildings constructed. Current tenants include a landscape contractor and research offices. The use proposed by the applicant for the dog training services for private and group classes and only boarding for dogs for training purposes is consistent with the zoning resolution's definition of kennel. The applicant indicates that while most of the training will be inside the building, the site does contain a large, open, non-fenced, grassy area which the property owner and applicant have agreed will be used for training purposes. While the facility does not sit directly on Centennial Road, staff recommends that the outdoor area be fenced due to the safety concerns of heavy truck traffic common to the area. Further, Section 2204B states that suitable fencing should be installed around pens or enclosures. Access and parking in the area are suitable, and the existing on-site parking appears to exceed the necessary 12 parking space requirements. Landscaping meets current requirements. Staff recommends approval of the requested conditional use permit for 3315 Centennial Road. The current request is compatible with the guidelines of the township's resolution and is specifically stated as a permitted conditional use in M1 light industrial districts. It is recommended that as a condition, any outside area utilized by the applicant be fenced. Approval may be further subject to the conditions as proposed by the Lucas County Plan Commission by separate document and any other additional agencies requiring compliance with their conditions. Some of those were things that the applicant was going to be checking with her landlord, and which had to do with some of the sanitary engineer fees and cash to tap. So that is on the applicant, and she has been made aware of that. And then really the other condition that the Plan Commission had said was also recommending a fenced area. So
Thank you,
that
Carleen.
concludes my report.
You have questions? Carleen, go ahead.
I have one. In the kennel, it says licensed to operate a facility for housing of domestic or exotic animals.
That's in our zoning resolution.
What
That
is
is
an
the,
exotic animal? Lion?
yes,
Bears.
Lion?
lion, tigers, and bears. Yeah, I thought that was interesting too when I pulled the definition of kennel out, so, but this is strictly a dog training facility, but certainly,
Okay, so there will not be any...
they will not be training any exotic animals,
Okay.
simply dogs.
No giraffes or...
No giraffes, no tigers, no
All right,
lions.
that's all I have.
I have, I think, two questions. First of which we talked about, you mentioned boarding of the dogs, that's just in the daytime, no overnight stays, no,
I think that the applicant is...
When the applicant comes up, we can have her speak to that.
So, it was any boarding was going to be related to training,
okay.
so,
And then the fence, the property that we're recommending be fenced is owned by the landlord?
Yes.
It's just undeveloped property?
Yes.
Or is that, sorry. if my-
so, or adjacent, adjacent to the building that they had agreed that they could use for training.
Okay.
So, and she did provide videos that I watched that, where the dogs were out in public, and they would have them sit, look like they were in a retail store, and then the owners would drop the leash and walk around to try to get them used to listening while distracted, and I understand because but I also told her prior to coming here to make sure that she talked to her landlord about that fencing application in case you did make it a condition due to the area that it's in and the traffic.
So there's a couple maps that you included in our write-up here. Can you show us what unit and what grassy area that you're speaking to? Like on figure 5.2? Maybe just come up and show us.
I'm assuming that it's in here, because they're behind the barn. I will get my PowerPoint presentation skills up to par. It's this grassy area, they're back behind the barn. This is the barn restaurant, and they're back here. So it would be in this grassy area.
So, yeah, the bottom left-hand corner of that.
I know where we're at.
5.2, yeah.
And then what was I didn't quite understand what the county's question was pertaining to sewer.
They were to talk to their landlord about that, and I had a conversation with the county as well on that, and they just needed to get that situated with their landlord, whether those fees were on the property.
So this is
So this is, she's going to be leasing it, and to me, that is an owner's issue, but they need to clear that up with her
That's
on the lease.
a matter of information.
Yes.
Any other questions of Carleen?
No, thank you.
Would the applicant like to come up and speak? So you can sign your name on the log there and then state your name for the record.
I'm Michelle Douglas with Simmons of Toledo. And we've been running the Simmons of Toledo out of the home for the past 2 years now, looking to secure space. And so this going through we found Centennial Road at 3315 and working with the landlord, but we wanted to do it right and coming in front of the board and making sure everything's set before we finalize a lease and everything. And I wanted to answer a couple questions that had come up. And one of the things, boarding for training, we offer board-in trains where we basically take the dog in. It does include overnight boarding. And so to answer your question, yes, it is included in overnight boarding. And with that being said, we do have security systems that will be installed and in place, staff that's within 15 minutes away if we need to get there within a certain period of time. The other question too is, and I couldn't find my piece of paper in regards to the group class where we would do it if we didn't hold it outside. It's not something that we have to do outside, but he has a grassy area, which is just catty corner to where the facility's at. So it's actually, literally, the amount of space we would need to utilize is maybe this much space of that grass area. It's not to fill up the whole area of this space.
So, both the county and the township represented having that area fenced. What are your thoughts on that, and what were your landlord's thoughts as well?
So in initially looking and talking to the landlord and he giving us approval to utilize the grass space, we did provide him with pictures, just like we did to the township in regards to pictures of us having a group class outside. It's currently held at Woodlands Park. I do have pictures printed up so everybody can see, and it did include videos too, where it is a matter of teaching the dogs obedience, no matter what the level of distraction is. So we do hold a group class during the summers outside. Right now, we've been holding it in the winter inclement weather at Family Farm and Home, and it is not a fenced-in area, and the park has great distractions of other people, other dogs that aren't trained and barking at our dogs as they're walking by. And honestly, we don't need a fence. I can understand the concerns, but we're not a doggy daycare where the dogs just run loose. The dogs are on a leash when they are outside in public like that type of environment. They are, in a sense, under control. And so, in talking to the landlord in regards to the fence, there are a couple of options that we do have, but we don't, what we're asking is for the recommendation to forego doing the fence, that we are responsible about it. If there are complaints from the landlord or any of the tenants, it is something that we would address right away, because we are a professional business and we are franchised, so we're not just upholding ourselves, but we're representing a brand.
Right. Okay, thank you. Other questions? Al?
I understand what you're saying. If this board would approve these stipulations, would you put a fence in?
That was going to be, I actually have two questions on that. Well, one question and then one. It is not a make or break deal. If you say put a fence up, and because it is a short-term lease, honestly, because the landlord's unsure how we're going to be representing his building, is not an expense that we would incur to put up a permanent fence. But if it is an option, I did look into portable fencing, where I have utilized portable fencing in the past for events, because we'll do group classes at events. In the past, we've done that too, where if it is required, would this be applicable to be utilizing a portable fence that we can put up for group class and take down, because this is not our property to put up a permanent fence.
Sure. Does that answer your question?
And that's not the answer I wanted, but that's fine. I think we made a recommendation to have a fence, a permanent fence, for the protection of you and other people around in that area, and that's why we put that in there. So I'm just making a point for myself here that it would have to be along our zoning recommendations, and I just want to see how you'd answer that.
So to clarify, your proposal would be, instead of a permanent fence, that any time you took these animals outside in a group setting, that you would bring this portable fencing along and you would fence them off?
Correct.
So you talked about, I guess building on what Al said, and I don't know if this makes it a little bit of a difference, but have you talked to the landlord themselves about putting a fence in, making it more of a permanent structure for their other tenants as well, sort of killing two birds with one stone, where you need the fence, but also might add value to other tenants? Because I'm with Al and some of his thinking too around the need for a fence to be a little bit more of a permanent structure versus portable. I wasn't sure if the landlord had said, hey, that might be an improvement he or she would be willing to make for the aesthetics of the entire building?
So any discussions through the landlord has been through our realtor, and he has made the landlord's realtor aware of the conditional use and all that. I have not gotten a response in regards to what he would do. And that was something that our realtor said, let's wait till the zoning board meeting and then bring it to the landlord.
Okay, fair enough.
So if this operator left and another kennel came in that wasn't strictly training, would they have to apply for a conditional use?
No.
If they weren't doing training, just selling?
Yeah, just say Karnak was
Just-
gonna open up another location, and this was a kennel, although it's not set up to be an overnight kennel, but they, you know.
Act like a kennel.
That the conditional use was on the property.
I would think they would have to get a new conditional use, as this one is specifically for dog training and boarding. Maybe legal counsel could weigh in on this, but I believe it would have to be a new condition.
That granted to an applicant, not to the property, but to the applicant. So that if someone else takes over the property, they would have to come and get another conditional use, even if it was very similar, a similar one.
Okay. That's the answer I needed, thank you. Any other questions for the applicant?
No, thank you.
Is there anyone else that would like to speak on this matter? Okay, you may be seated.
Were the neighbors notified? Letter, any response?
Yes.
Yeah, a response.
I suggest we take a quick recess.
I agree.
Okay. So, at 5:49, quick recess.
I wanted to read quicker, but I could.
Nice job. Proud of you.
Ron?
Thank you.
Call the meeting back to order at 5:58 PM. So we have a motion.
Mr. Chairman, I'd like to make a motion for the conditional use for a kennel within an M1 district for the property located at 3315 North Centennial Road, parcel number 78-28706, with the Sylvania Township zoning regulation, section 1602, with a condition of a 4-inch chain link.
4 foot.
I'm sorry, 4-inch, very small, thanks. 4-foot chain link or split rail with wire fence.
I second that, Mr. Chairman.
Motion second.
Only the size of the area, where'd you go? Only the size of the area that you would use. You wouldn't have to fence that whole piece of property there. Is that all right, Mr. Chairman, to say that? Okay. So if you only need half this room, you'd only have to fence half of it. Understand?
Can I ask a question?
Sure.
What if we don't utilize outside space for group class until we secure a long-term lease?
Okay, for the
Would
record.
that affect the condition?
Why don't you come up to the podium?
I think the motion's been seconded, I have to vote on it or remove it. I think we have to remove his motion because it's seconded. Withdraw his motion.
So before you speak, would you like to withdraw your motion? Can we open up the testimony again?
Yep, I'll withdraw.
I apologize.
That's why we're here. Go ahead.
So my question is, in regards to the fencing, is it possible to not utilize outside spaces until we secure a long-term lease at this building? Meaning that we still get approved for the conditional use of the interior and not utilize group classes outside till we earn the landlord's trust that will take care of his property. And at 1 year of renewal, we renew for long-term.
We'd have to split those those motions up if that's the case, correct?
Well, the initial conditional use was strictly for the building. The outside came into play when I was contacted after I turned in the conditional use. And they asked if we were going to be utilizing the outside space, and during discussions with the board, the zoning committee here is when I reached out to my realtor and saying, well, we would like to, and he talked to the landlord, and the landlord said we could. So the conditional use application initially was for the building itself. Upon questions, when the zoning committee contacted us in regards to what we were doing, asked if we were going to utilize the outside space, and I said the landlord said that we can utilize the outside space for group class only, and so that he got all the information that he needed in regards to also asking number of dogs we would have, that type of thing. And so I wasn't sure if it was actually included as part of the initial conditional use application.
So, probably the right way to handle this would be for you to put an agreement together with your landlord that you understood, meaning that your lease would dictate use inside and or outside, and if your lease said that you could utilize the space outside, we would need it to be fenced.
Okay.
So, my suggestion on this is, do you have a really tight time frame on this?
Yes.
Go ahead.
Could grant the conditional use permit on the use of the building only, and have her come back after that year if she's going to be a long-term
What I'm trying
tenant.
to avoid is a policing issue.
Right.
I'll send Dean over there. It's not a problem.
Your responsibility?
He's out and about. Dean will go.
Yeah, see, I'm looking out for you.
I knew you were back there. So, I mean, that's a possibility. Wait, I mean,
Could we put as a condition that no outside space be used for training?
Sure.
Yeah.
I'd be comfortable with that, Mr. Chairman.
I would be too.
Okay, so if you'd like to amend your motion,
Well,
or
actually,
how about a new one?
New motion.
Thank you.
I'll make a motion for the conditional use for a kennel within a M1 district for the property located at 3315 North Centennial Road, parcel number 78-28706, STZR section 1602, with the condition of no outdoor training.
Second.
We have a motion and a second. Call for the vote.
Mr. Lemon?
Yes.
Mr. Schlechter?
Yes.
Mr. Miller?
Yes.
Mr. Hayes?
Yes.
Mr. Levine?
Yes.
So that carries, so you have the conditional use to use only the inside of the facility. And if you choose to go outside, then you'd have to come back and request. Okay?
Okay.
Thank you. Okay, the next item of new business, there are two on the same property. It's a variance request for the east side landscape buffer when abutting residential from 30 feet required to 1 foot provided for the property located at 2807 Scarlet Oak Drive, parcel number 79-70617, Savannah Township zoning regulations, section 3002-A. The second request is a variance request for the south side landscape buffer when abutting residential from 30 feet required to 1 foot provided for the property located at 2807 Scarlet Oak Drive, parcel number 79-70617. Okay, so would you like to read the staff report?
I will do so.
Thank you.
I'm sorry that Jerry's drawing isn't on the board, and
It was a work of art,
we'll
yes.
get it there next time. The staff analysis is, the subject property is approximately 3,700 square feet of land, which has been split off of parcel 79-07617 for the specific purpose of creating 8 additional parking spaces for Yark Automotive. I've been told it's located at the far end of Fairbanks, at the back of the Yark operations, abutting the condominiums on Scarlet Oak Drive. Yark and the property owner have reached an agreement, and the property owner, as the most affected by these variance requests, has not objected to the variances. The applicant is applying for landscape buffer. The applicant is applying for 2 variances from landscape buffer requirements. The applicant is requesting relief from the 30-foot landscape buffer required when abutting residential property to 1 foot provided on the east and southern sides of the property. 30 feet is required per section 3002-A of the Saline Township zoning resolution. Staff recommends approval of the requested variances pending approval of a zoning change from the minimum rear setback for the property located at 2807 Scarlet Oak Drive on approximately 37 square feet, 0.085 acre split off of parcel number 79-70617. The design of the cul-de-sacs, lack of other access to off-street parking, and abutting against the residential area create a practical difficulty for the business, as there is no other way to obtain access to off-street parking. The split parcel, in agreement with the property owner, is the only way to obtain this off-street parking. Currently, there is no landscape buffer in place, and if granted, a buffer will be installed. Should the variances be granted, staff recommends that the BZA attach as a condition of approval that the applicant's request for a zoning change must be approved.
Thank you, Carly. Any questions for her? The applicant like to step forward?
Yes, hi, Jerry Parker, and I represent Yark Automotive, who's requesting these variances. There's aerials, I think you have the aerial, but you can see, not to be facetious, but I've taken bigger divots planed off than this piece of ground.
I've seen that.
The importance of it is for Yark Collision, if you've ever been back there, they're just out of parking, and this, even though it seems like 8 spaces, more would you want 8, they need the 8 to keep the cars from parking on the street, quite frankly. And in any event, the property owners, this is a condominium, all the owners of the condominium are actually our sellers, okay, so they're in conformance with it. And what the big advantage here has been mentioned by the staff is that right now, there's no barrier but a wire fence. This will be an 8-foot fence completely around, so they won't see the parking lot once this is granted, so that's a big plus for them. So we didn't ask for a variance from the requirement of an 8-foot solid fence, so the plus is they won't see the parking. And we didn't want to take any more ground, obviously, and so therefore that 30-foot up against residential, if it stayed in place, would make this not feasible. So that's why we requested it. And obviously, we concur with the staff, and the condition that's attached was that it be rezoned.
Any questions for Jerry?
What type of fence will it be?
It's a solid fence. If the staff has a preference, it's not, whatever they'd like in terms of the fence.
I'd like to see the same fence that we've been using, which is the same type of fence that goes around Taylor, Cadillac.
Yeah, the white fence.
Privacy fence.
That's the one I had.
8 foot tall.
It's the same one I think many years ago we put back there, right? It's nice looking.
And we've been
That's
using
fine.
that lately, and I think that would,
Make it look better, right?
Yeah,
I
I agree with Al.
I'm sorry?
I agree with you, yeah.
Okay.
That can be a condition. I have no problem with that.
Okay. Any other questions? So would someone like to propose a motion with zoning and fencing included?
I can do it. I want to make a motion, Mr. Chairman, for a variance request for the east side landscape buffer when abutting residential from 30 feet required to 1 foot provided for the property located at 2807 Scarlet Oak Drive, parcel number 7970617, according to the Sylvania Township zoning resolution, section 3002-A, on the condition that the zoning change be approved and that the applicant installs an 8-foot solid white fence around the area.
And can you add the
Second
seventh variance to that as well?
And I'll also add the second variance request for the south side landscape buffer when abutting residential from 30 feet required to 1 foot provided for the property located at 2807 Scarlet Oak Drive, parcel number 7970617, according to Sylvania Township zoning section 3002-A, under the same conditions. So zoning change and the 8-foot solid fence.
Thank you. Second. Motion second, call for the vote?
Mr. Levine?
Yes.
Mr. Hayes?
Yes.
Mr. Valano?
Yes.
Mr. Schlechter?
Yes.
Mr. Miller?
Yes.
Thank you very much, appreciate it.
So last on our agenda is a variance request for a front side yard setback from 30 feet required to 25 feet provided for the property located at 3361 Waldmar Road, parcel number 78-53831, Sylvania Township zoning regulations, section 703. I have the staff report.
Staff analysis, the subject parcel is a corner lot in the Lathrop Place subdivision occupied by single-family dwelling facing Waldmar Road. As with all corner lots, the parcel has two frontages. The applicant is requesting a variance reducing the setback a total of 5 feet from the required 30 feet to 25 feet for construction of a garage. Section 703 of the Sylvania Township zoning resolution dictates that setbacks for corner lots shall have the required front setback on both street frontages. For the property, this property, the requirement is 30 feet from Waldmar and 30 feet from Bonsall Parkway. Applicant states there are other garages constructed in the area which do not meet the 30-foot setback on corner lots. A review of measurements of similar properties in the area by staff did result in mixed results. The size of the garage desired by the applicant and the requirements of Toledo Edison for connection to the pole of the transformer have created a unique situation for the applicant. Toledo Edison's denial of the use of a pole on the northwest side of the property, forcing the line location to the south side of the property, is beyond the applicant's control. In order to construct the garage, cables had to be buried, and the required location of the buried cables present construction of the garage in the area, requiring the requested variance of 5 feet reduction in the setback. Staff recommendation, reduction of the 30-foot requirement to 25 feet requirement provided is not inconsistent with other properties in the subdivision and does not result in any use outside the terms of the Sylvania Township zoning resolution. The hardship is not created by the applicant but by the utility requirements of Toledo Edison, which has created the unique condition relevant to the applicant's corner property. Staff would recommend approval of requested 5-foot variance from the minimum setback of 30 feet from Bonsall's Parkway.
Thank you, Carly. Questions?
None.
Is the applicant here?
Yes, sir.
Would you like to write your name and then state your name for the record?
Good afternoon. I'm Richard Castleman, the property owner, recent property owner, I should say. And, I'm requesting this garage so I can stow my truck in it. I hate to leave things set outside, so that's about it. I think my letter and everything, the attachment to it, pretty much explained everything, so it's up to your pleasure.
Okay. What questions do you have of the applicant?
Have any?
One quick question pertaining to Edison. So, when you made the application for permanent power there, my assumption is they dictated where
Correct.
it was to be placed?
There's two poles at the rear of the property. One is out by Bonzel's. There is no transformer on that. They requested that the line be buried to the one near the inside.
Right.
Probably, I'm estimating might be 30, 40 feet from Bonzel's, and it's at the rear property line. That's where they wanted it buried from, and there were trees in the way, so we had to sort of zigzag our way through those, because I'm taking out all the trees. The tree people did not want to go on there, take out the trees because of the power lines overhead.
Sure.
And I had to go buried because of the garage. It was a low-hanging drop, so it would have been too close to the garage. So that set up the condition of, I wanted to go over to Bonzel's, then would not have presented any problem.
Sure. Okay. I appreciate the clarification. Someone have a motion?
I'll make a motion. Variance request for the front side yard setback from 30 feet required to 25 feet, provided for the property located at 3361 Walmart, parcel number 78538331, STZR, section 703.
Second?
A motion and a second. Have a vote, please.
Mr. O'Donnell?
Yes.
Mr. Schleifer?
Yes.
Mr. Miller?
Yes.
Mr. Hayes?
Yes.
Mr. Levine?
Yes.
Thanks, Serge.
That's approved. We'll get official notice here in the next couple of weeks. Is there any other business before the board? No. For adjournment?
Second.
There's a motion to adjourn.
Mr. O'Donnell?
Yes.
Mr. Schleifer?
Yes.
Mr. Hubbard?
He's not here.
Traveling.
Mr. Miller?
Yes.
Mr. Hayes?
Yes.
Mr. Levine?
Yes.
Thank you. We're adjourned.